Good afternoon, and welcome to another edition of Ask Judge Carol. Thank you so much for joining me. Today, we are going to be talking about the subject when tragedy strikes. And as you may know, I am here doing these sessions because I'm on a mission to help you to understand how the law applies in your life as you navigate the various challenges and hopefully make them less challenging through helping you to understand how the law applies. So I say that my mission is empowering lives through education about the law. So this session is to help you to understand how the law works. And as you will probably be aware, we have faced some really horrifying tragedies recently within the Bahamas. There have been a number of traffic accidents that have resulted in deaths in very horrible circumstances. And then there have also been some recent airline incidents, air traffic incidents, two on the same day involving a particular airline, and one of those incidents resulted in a number of fatalities. Now, I have been talking for the last few sessions. Sorry, I'm going to just connect. I don't want my laptop to die while we're proceeding. Okay, so I've been talking in these sessions for the last few weeks. We talked about wills, the importance of having a will. I also went through probate and administration of estates and that process and what it means to have an estate. So, and then even just as recently as last week's episode, which was episode 6, when I talked about life insurance. And so we are going to be kind of building on that information in today's session. So I encourage you to go back and review those previous episodes. And I'll mention it here, and I'll mention again at the end of the session that I do offer for free a will preparation kit. So all you need to do is send me an email at info@judgecarol.net and ask for your free will kit. You can fill it out and then you take it to your lawyer to draw up the actual will for you. Or you can send me a WhatsApp message at 451-4855. That's 451-4855. And say, Judge Carol, can you please send me your free will kit? And then we will send that right over to you. So let's get into today's topic. Now, the background, as I said, or the angle that I'm coming to you, the angle that I'm coming with is the recent fatal accidents. So there are a few pieces of legislation that we have in the Bahamas that speak to this topic that you will want to be aware of. And in a way, 3 different processes that will run at the same time, but they have different implications, different angles. So one is the individual or civil track. So what a family member, what an individual person can do, what are their options, what are the considerations that they should be aware of. So there's the individual, there's the state represented by the police and or the Attorney General's office. What are the questions that the Attorney General will be considering addressing his mind to, the question of charges and so on. And then there's also the coroner's track. The coroner's track, which has there's the Coroner's Act, which sets out what a coroner is supposed to do, how the coroner operates, and so on. So today I am going to mainly focus on the individual track, and if I have sufficient time, also, which I hopefully will, also touch on the coroner's track. Anything that I don't get to cover on today's episode, I will continue on this topic on the next episode. So the civil track, what an individual can do. I'm going to check my notes from time to time, so pardon me as I hold my head down because it's a lot of information to cover. So there are claims under the Fatal Accident Act. The Bahamas has a Fatal Accidents Act, which provides that a dependent of a person who has died as a result of an accident can make a claim against the person who committed the wrong, caused the wrong, if you will, for a loss of dependency. So the claimant under the Fatal Accident Act is a dependent, and the person against who the claim is made would be the defendant in a claim. Now, let's clarify, or let me explain who dependents are under the Fatal Accidents Act. So a person, the Act says where the death of any person is caused by a wrongful act, neglect, or default of another person, and the default would, but for his death, entitle the person injured to maintain an action for damages, then so you have someone who has caused an act and someone who suffers as a result of an act. So if there's a legal claim that arises, so it's not just anything that happens, but if there's a basis for making a legal claim, then if you are a dependent, you are able to make that claim. And so the particular kinds of relationships we're talking about would include an adopted person who was treated as a child of the person who was killed in the accident, any relationship of affinity, that is through marriage. So, for example, a stepchild can be considered as a dependent. Any relationship through marriage is also treated as being someone who is eligible, as well as an actual blood relative. Any relationship of the half-blood is included, as well as the whole. And an illegitimate person shall be treated as the legitimate child of his mother or reputed father. Now, you know that under the, I think, in Inheritance Act, we don't use the term illegitimate any longer, but the Fatal Accident Act, when it was passed in 1976, obviously predated by a few decades the provisions of the Inheritance Act. But just to be clear, so that you understand, relationships through marriage, relationships either in marriage or through marriage, blood relationships of the half or the whole blood, and adoptive relationships all qualify as being able to bring a claim under the Fatal Accidents Act. So that's who. Then you have the question, then when, and you have 3 years under the Fatal Accidents Act from the date of death of your loved one who would have died in the accident to bring a claim under the Fatal Accidents Act. And there's only one action per death. So, and it's brought by the personal representative as the nominal claimant on the dependent's behalf. Okay, so that's the Fatal Accidents Act. Claims by a dependent in respect of a family member who has died. But then you also have claims under the Survival of Actions Act, which is which is a claim by the estate of the person who died. So remember what I've said in previous episodes, that when a person dies, their property, and this also notably includes claims against them or on their behalf, survive by virtue of this act, for even though the person died. So if you think about someone who has died in a traffic accident, it doesn't happen that when that person dies, nobody can be sued. The action survives for the benefit of the estate. So if, let's say, but for the fact that they died, they could have sued for the traffic accident, aircraft accident, or whatever other kind of accident. It could be a slip and fall even, and someone has a terrible accident and they perish as a result of that accident. The person who caused the accident, who is legally responsible for that accident, is still liable to pay the estate. So their personal representative can sue, or let's say that the accident happened, the person hired an attorney and brought a claim in the court, but after the case was filed, but before the case was heard, the person died, then a personal representative can be named, and they can still carry on that case to its conclusion and receive an award of damages. Or if the person died before any case was brought, their personal representative can still bring a case for damages, for negligence, for wrongful death, or whatever format the legal claim would take. But your estate, the person's estate, can still claim damages against the person who committed the wrong. So the limitation is a 6-month period. So remember now, under the Fatal Accidents Act, dependents have 3 years to bring a claim against the person who caused the death. In the case of the estate's own claim, if you're bringing it in the name of the person as their personal representative, you have 6 months from the grant of representation. Remember, I spoke to you about grants in an earlier session. So if you have a grant of representation, you go to the court, you file your probate, then, or for letters of administration, if there was no will, you have 6 months from the grant of representation to bring a claim against the person who committed the wrong for the benefit of the estate. And a third point that I would mention is that any liability in respect of the cause of action. So cause of action is a legal term, and basically it means that there's a legal claim, there's a legal liability. So not any and everything that someone does can form the basis of a claim in law. If the act is recognized as being foundation for a claim recognized by law, we call it a cause of action. So if there is a cause of action in which proceedings can be brought and maintained, then even though the person who caused the accident died, you can bring a claim against that person's estate. So You can have a claim for an estate when the person died who suffered the accident. You can bring a claim against the estate of the person who caused the accident. So the person who suffered the accident or their estate can claim. The person who caused the accident or their estate can be sued. That's what our Survival of Causes of Actions Act says. Very important. So 2 takeaways we have so far: claims under the Fatal Accidents for Dependents and claims under the Survival of Actions Act for an estate or against an estate. Now, application to traffic accidents. There is the possibility, as you may well imagine, and in fact we've heard in the news, that charges could be laid. There can be charges under the Traffic Act for traffic offenses and possible other criminal charges, traffic charges or criminal charges. Those are matters that would be within the purview of the police and the Attorney General's office. So those are not individual claims. A person who is driving or a passenger does not have the right to decide to sue. They don't have standing to sue or to lodge a complaint in court with respect to traffic laws. That is something that is within the purview of the Attorney General's office, filing cases in respect of traffic laws. And then there are provisions under the carriage by air regulations for accidents that have happened as a result of aircraft carriage by air incidences. And I think that I hopefully will have someone who is an expert in air traffic, in airline regulations, aircraft regulations, to be with us next week to talk about the implications of airline accidents, which is an area that is definitely outside of my particular expertise. I have a general understanding, so I'm going to take the opportunity to bring someone forward next week to talk about the airline and aircraft aspect of the recent incidents. The other part that I mentioned earlier, so remember I said there was the individual track, there's the state track, and then the coroner's track. So I'm going to touch on that. And I just want to say thank you to those of you who have joined me today. I haven't seen any questions pop up yet, but certainly please share your questions with me and I can try to answer them. So the other aspect of the law that you would need to be aware of and to understand is the role of the coroner's court when we have tragedies such as these that we have been faced with as a nation. So we have a coroner's court in the Bahamas, and we also have a appointed coroner. The Act provides that any magistrate can serve as a coroner. What normally happens is that a person is designated as a coroner or possibly as a deputy coroner. We are fortunate that we have a designated specific coroner. And the coroner's duty is to, all unnatural deaths, basically, you can think of it this way: all unnatural deaths have to be reported to a coroner, either by an individual or by a police officer. But in any circumstance, where there's been an unnatural death, it must be reported to the coroner. And then we're going to talk about the rules and how the issue of, whether there's an inquest or not, and all of that comes into play when you're looking at the Coroner's Act. So reporting of deaths. A person must, immediately after becoming aware of a death that is or may be a reportable death, notify the coroner or a police officer of the death, unless the person believes or has reasonable grounds to believe that the death has already been reported. So you as an individual, obviously that wouldn't be the case that we're dealing with these particular tragedies, but so that you can be aware, you have an obligation as an individual to go to the coroner or to report it to the police, who then have an obligation to report it to the coroner. And the person notifying the coroner must give the coroner or the police officer any information you have in relation to the death, or if it's the case of a medical practitioner, they give information to the coroner regarding the circumstances of the death. And if you fail to notify the coroner, if you are aware and fail to notify the coroner of a death, an unnatural death, you can be liable to prosecution and conviction and a fine or imprisonment. So the law takes very seriously the reporting of deaths, right? Now, so in circumstances like this, when I say like this, we're talking about the recent tragedies, the traffic fatalities and the aircraft fatalities. A inquest may be conducted by the coroner, and a coroner opens and conducts an inquiry for three purposes. Firstly, to establish certain things, namely that the person has died, the person's identity, when and where the person died, the causes of death, and the circumstances of death. So those are the things that a coroner's inquest will look to establish. The second purpose is to make recommendations or comments that, in the coroner's opinion, may reduce the chances of occurrence of deaths in other such circumstances similar to those in which the death occurred. So it's to establish certain facts, to make specified recommendations, and thirdly, to determine whether the public interest would be served by the death being investigated by other investigating authorities or persons with other functions, powers, or duties. So those are the reasons why an inquest, why the coroner would hold an inquest. Now, what is interesting and helpful to note regarding how an inquest is conducted? I think you will probably be familiar, at least have a concept. You have magistrates' courts and Supreme Court, where the magistrate or a justice will conduct a trial, and they take evidence, and then in the case of the Supreme Court, you have the jury who renders a verdict. In the magistrate's court, the magistrate is the judge of the fact and the law, so there is no jury. In the case of a coroner's inquest, it's kind of like a hybrid, to the extent that the magistrate, actually I should say the coroner presides over the hearing, and the jury considers the evidence. The purpose of the inquiry is, the purpose of the inquest is to inquire into the circumstances of the death. So it's not a trial. There's no person who is on trial in a coroner's inquest. It's an inquiry. And the coroner the inquest isn't there to find somebody to blame. So if you have a magistrate's court or a Supreme Court trial, somebody is quote unquote on trial, and the idea is to determine if they are guilty or not guilty. Are you at fault? Are you not at fault? If it's a civil trial, then the question is, are you liable or are you not liable? The coroner's inquest is an inquiry to examine all of the circumstances. There's no question of attributing blame, although the jury or the coroner make recommendations, as I mentioned earlier, for further investigations to be carried out. Some evidence may be read out without witnesses having to attend, and the family will have the opportunity to question witnesses through counsel if they have one, or if they don't have counsel, if they don't have a lawyer at the coroner's inquest, they may be able to ask questions themselves, probably through the coroner, to put the questions to the various witnesses. And the rules of trial are not as strict in an inquest, so the court may take the inquest, I should say, may receive hearsay evidence. The idea being that the best way to uncover what really happened is what they are looking to achieve. This is a little bit similar as well to, for example, in the quieting titles investigation, where the rules of evidence are a little bit relaxed. They're more relaxed than in a trial, where you're looking to fix blame or fix liability on someone. So there's a similarity there between the quieting titles and coroners versus a trial on liability for civil cases or on investigation, trial for an offense where someone is looking to be found guilty or not guilty on a charge or charges. So that is the information that I have for you today. I know it's a lot of information. You might want to go back and watch this episode again so that you can kind of take it all in. But just for a brief review of what we talked about today, is that there are a number of aspects of the law that come into play for situations where there have been fatalities as a result of accidents. These are governed by the Fatal Accidents Act and the Survival of Actions Act that deal with bringing claims for or against an estate. Under the Fatal Accidents Act, there's a 3-year limitation. Under the Survival of Actions Act, there's a 6-month limitation from the date that a grant of representation is made. And then, so those are claims by individuals. Then there's a role that the state has to play through the Attorney General's office, which is looking at whether charges should be laid in relation to offenses for breaches of particular statutes on behalf of the state. And then there are coroners' inquests. The role of the coroner is to investigate. First of all, the deaths have to be reported and advised to the coroner. The coroner will conduct an inquest. And then next week, we are going to look as well, more particularly into claims regarding aviation accidents. And we will have an expert come and talk to us on the law about regarding aviation accidents, requirements, and claims, and limitation of actions in respect of that can help you to understand and have a basis for managing all of this information. So thank you so much for being here. I would like to invite you to send me an email at info@judgecarol.net to get your copy of a will kit, and to stay tuned for future episodes of Ask Judge Carol. Thank you for being here and have a good afternoon.